11, Section 8-113 of the Oklahoma statutes addresses conflicts of interest. Subsection A provides in pertinent part, except as otherwise provided by this section, no municipal officer or employee or any business in which the officer, employee, or spouse of the officer or employee has a proprietary interest shall engage in 1. Selling, buying, or leasing property, real or personal, to or from the municipality, 2. Contracting with the municipality, or 3. Buying or bartering for or otherwise engaging in any manner in the acquisition of any bonds, warrants, or other evidence of indebtedness of the municipality. Violation of this statute is a misdemeanor. All transactions entered into in violation are also void. Also, any member of a governing body who approves a transaction in violation of this statute will be personally liable for the amount of the transaction. There are several exceptions to this section of the statute. Some of these include officers or employees of any municipality with a population of not more than 5,000 who has or have a proprietary interest in a business which is the only business of that type within 5 miles of the corporate limits of the municipality. Expenditures, if competitive bids were obtained consistent with municipal ordinance or state law and 2 or more bids were submitted. Officers, directors, or employees of a financial institution that serves on a board of a public body, and the purchase of surplus property. However, there are numerous caveats to these exceptions, and each must be reviewed carefully in order to prevent running afoul of the statute. Article 10, Section 11 of the Oklahoma Constitution also addresses conflicts. It very clearly applies to members of governing bodies and provides as follows. The receiving, directly or indirectly, by any officer of the state or of any county, city, or town, or member or officer of the legislature, of any interest, profit, or perquisites arising from the use or loan of public funds in his hands, or monies to be raised through his agency for state, city, town, district, or county purposes shall be deemed a felony. Said offense shall be punished as may be prescribed by law, a part of which punishment shall be disqualification to hold office. Violation of this section of the Constitution is very serious. As discussed in Attorney General Opinion 2001 OK AG 32, even a recusal from a vote may not be enough to cure a conflict of interest. Pursuant to Section 11, if a conflict of interest exists, it cannot be avoided by any means. Care should be taken by all officials to avoid even the appearance of impropriety.